Great.
Okay. Good morning, everyone. I'm Jody Zellner with Safe Harbor Financial Advisors, and welcome to Ask the Expert, a webinar series where we spotlight the incredible business owners who make Tampa Bay such a special place. Each month, we sit down with a local expert to learn their story, their passion, and the tips they wish everyone knew. Our guest this week is John Beck, Esquire with Colin and Wagner, PA. So, John, tell us a little bit about yourself and what led you into estate planning.
John Beck, I'm partner with Colin and Wagner. We're a law firm. And so my background, I started off in accounting, decided I liked the tax law aspect of accounting. Ended up going to law school. And then after that, obtained my LLM, which is a 1 year specialization after law school focused in tax and estate planning. And that's really what brought me into the estate planning side. During the LLM program, just realized that I was passionate about the estate planning side. It mixes in a lot of the legal work with the tax side, which is what I was doing before going to law school.
Okay, and what kind of clients do you typically work with today?
We work with all types of clients, broad spectrum of clients. So we have clients who are extremely well off, business owners. Uh, we have large businesses, small businesses. Virtually every person should have some sort of estate plan in place, or at least some of the documents of an estate plan. So we're dealing with all types of clients.
Now, is there a moment or experience early in your career that shaped how you approach estate planning today?
One of my first clients, just a couple months into practice, had a client come into the office. Unfortunately, her husband passed away, and he was running a very successful business. And he was doing it on his own. His wife wasn't really involved with that business. When she came to us, she was having issues already trying to access the bank accounts for the business, issues signing contracts because she wasn't listed as a manager or anyone with authority with the business. And she just assumed that everything should be put into her name automatically upon her husband's passing. But unfortunately, since he did not have an estate plan and he did not set anything up during his lifetime, she had to go through probate in order to obtain that business interest. And it was very difficult for her. She had to use some personal funds that she had in her name in order to keep the business afloat. Going through the probate process was very stressful for her. So, with estate planning, we can handle all of that ahead of time so that if, God forbid, something does happen to a business owner or manager, things can transition smoothly, no time is wasted, because it's imperative, especially with a business, that everything is seamless so that the business can keep operating smoothly. And that doesn't just apply for businesses, it applies pretty much everything. But since that experience and a number of experiences after, it's not an uncommon problem. When I meet with a client, I always want to make sure everything is handled for them, that they have a plan for what would happen if they were no longer here, so that their spouse or kids aren't left in that same situation.
Okay, so you touched on a couple of things there, especially with regards to business owners who are my bread and butter. So I love them, but sometimes convincing them to do estate planning is like twisting arms. But let's start with the first part of the continuity. How can estate planning, with that example, how could that you mentioned, how can estate planning help with business continuity to keep the business going?
Yep. Well, and I understand business owners are very busy, so getting this on their plate as well can be difficult. But um, estate planning can, there's a number of things that we could do for a business. So if, let's say, that husband that passed away came into us during his lifetime, we would look at a couple options. So if it's a simple, smaller business, operations are just with that one person, and he knows exactly who he wants to take over everything upon his death, we could have just done a simple transfer on death document, very easy to put together. That way, if he passed away, his wife would automatically be able to step in and start managing that business immediately, update the Florida records. There'd be absolutely no delay in the continuing administration of that business. There are other options. So we could also set up a trust to hold the business entity. When we do that, it's a little bit more involved. We would look at uh, essentially what are the tax ramifications of using a trust. Trusts have different tax brackets, so they have graduated rates, but they're not the same. One thing that a lot of people overlook that really isn't, it's vital to a business is what happens if that business owner becomes incapacitated. So the person's still alive, but they're not able to make decisions any longer. We can include that in their documents as well. So we could make sure that if one manager can't serve for any reason, they're incapacitated, you have another manager as a backup. And I like going 2 or 3 levels just to make sure we cover all of the contingencies.
Okay, now what do you do when you have multiple business owners? How does that affect the estate planning process?
Yep. So when you have multiple business owners, of course, it becomes more complicated. But in that event, we usually would at least have an operating agreement. That operating agreement would dictate how decisions are supposed to be made between the partners. So if one of them can't serve for any reason, the other ones can continue serving, or the one who can't serve is replaced by somebody else, whether that be a family member, a friend, whoever they want it to be. We also generally have what we call a buy-sell agreement, which is vital that that gets put in place properly, especially given some recent court decisions on how those are reviewed and scrutinized from a legal perspective and from a tax perspective. But a buy-sell agreement can outline how a deceased owner's interest would be valued, how the other partners could buy out that individual. When I set one up with a client, I look at it from every angle. So I'm thinking, how are the other partners going to afford to buy it? What kind of terms would make sense? Maybe they pay 20% in cash and the rest is through a promissory note that the other owners could pay over time, or have a life insurance policy. It's a great way to fund a buyout of a deceased partner. So a lot we could do when we have multiple business owners, but it does become more complicated, and there always needs to be communication between those business partners to make sure they're comfortable with the plan that's put in place for incapacity or death.
Okay, let's go back. You mentioned this earlier, but it kind of sums up this. You mentioned the dreaded P word, probate. What is probate and what role does that have, especially with regards to the business owner?
So probate is essentially a court process where whoever you appoint in your will, personal representative is what we call it in Florida. Other states, it's called an executor. But that person gets appointed by the court to handle that person's estate. The court oversees everything. So, probate process, court appoints that individual collects all the assets, pays any outstanding debts that the decedent had, provides notice to all of the beneficiaries. Court approval is required throughout the entire process, which makes it very time consuming. Unfortunately, the court doesn't move as fast as most of us would wish. It's just the nature of the court system, and they're quite overburdened. So, most people want to avoid probate, and there's a number of ways to avoid probate. With business owners, again, go back to what I mentioned earlier. Transfer on death avoids probate. It's automatic upon your passing. Whoever you designate to receive your interest, and it could be multiple people, receive that interest, or through a trust, in which case a trustee, whoever you appoint, takes control of your business interest and then disperses that ownership interest however you deem appropriate.
All right. And if somebody's listening today, whether a business owner or not, they realize they don't have a plan or it's an outdated plan, what are the first steps they should take to get that updated?
Yep. And an outdated plan would also include if somebody moved from out of state. So one of most common things we see, somebody gets their estate plan done in another state, moves to Florida. They think they're fine because they just did it a year or two prior. Uh, each state has unique laws. So, very important to have an in state attorney review your documents. For example, durable power of attorney would generally need to be changed regardless of from where you moved. Uh, Florida law is very, very unique in relation to the durable power of attorney. Uh, but if you think you need to update your documents, you don't have any current documents, first thing to do is think about who you would want to be in control of everything. You've earned your money, it's yours. You should use it for yourself. You are incapacitated. Who would pay your bills for you? That's the person in your durable power of attorney. Who would sign contracts on your behalf? Again, that's the durable power of attorney. Healthcare document. In Florida, we have the healthcare surrogate, advance directive, and living will, designating who you'd want to make medical decisions for you if you were unable to make those decisions for yourself, and also specify what type of treatments you would want or would not want. And then the other part of an estate plan, who would you want to receive assets and what would you want them to receive? Are there any restrictions you want to place on that individual? Are you worried about creditors for that individual? So essentially, to keep it simple, who would make your financial and legal decisions? Who would make your healthcare decisions? And who do you want to receive what?
Yes, you don't know how many times I talk to a client and what they want to make their 20-year-old son the beneficiary of their life insurance, and I'm like, whoa,
A
you know,
lot of money for a 21-year-old.
yeah, I know that would not have been a good idea when I was 20 years old. I'm just saying that probably a good thing I never came across money at that age. Okay, so you mentioned a couple of things there about updating their plan, reviewing their plan. So let's touch on two of them. One was the trigger events, moving obviously one of them. What other trigger events should cause somebody to review their estate planning?
If one of the beneficiaries or people that you appointed have passed away or is just no longer capable of performing those services for you, definitely a time to look at your documents again. Also, if God forbid you had a situation where you had a falling out with one of your agents, the person to make decisions for you, or a beneficiary, great time to look at your documents. And another time would be if, let's say, you had a new child or grandchild born. If your documents don't adequately take that into account, you may want to update them. When I set up an estate plan, I'll talk to my clients about this. When it comes to beneficiaries, I always like to have the document specify what happens if any of the beneficiaries pass away. What are the backups? How are things redistributed? But we do see documents many times where they don't go into depth on that. And there are some Florida rules that can really create a problem for you. So, for example, if you move to Florida and you have a will that says everything to my son John and my daughter Mary 50-50, then Florida law is going to say if John predeceases, his kids step into his shoes. Well, let's say John wasn't a son, John was a friend. If John passes away, it doesn't go to his kids, it goes to your other beneficiaries. So there's a lot of nuance that goes into an estate plan. So whenever somebody passes away, change in relationship, uh, I'd say just go to your attorney, give them a call if you already have an estate plan, let them know what happened, and then they could tell you if you need to update your documents or not. I have clients call me all the time for this, and generally just set up a phone call. Don't charge anything. We just go over the change. I take a quick look at their documents, let them know if they need to actually do anything or if it's already handled for them.
Okay, and you mentioned the beneficiaries a couple of times, and those are beneficiaries on insurance plans, beneficiaries on retirement accounts. How important is it for the client to make sure that he's coordinating his estate planning with his
Mm-hmm.
financial planning, his insurance planning, his tax planning, that all of
Yep.
you are on the same page?
Yeah, and that's one of the biggest issues we run into. We give our clients instructions on how to coordinate their financial plan with their estate plan, but obviously we can't go in and see their accounts unless they show them to us. So it's vital. So let's say you had a trust. You either need to move assets into the trust or have beneficiary designations to the trust in order to avoid probate. If you don't, then all of a sudden you have a probate and a trust administration, which is just going to slow everything down and increase the cost. Um, and even if you don't have a trust, you can have beneficiary designations on all of your financial accounts. Those do avoid probate. So every financial account should either be held by a trust or have a beneficiary designation directly to the people you want to inherit those accounts. And if you have a financial advisor, it's very helpful because whether it's a trust or just beneficiary designations, you can talk to that financial advisor, tell them what you want to do, and generally the financial advisor will help you put together those documents. You also generally would have a checking and savings account outside of your financial advisor. Make sure to have pay on death or transfer on death on those accounts. That avoids probate on the checking and savings account.
Good advice. I'm going to have to update some of my accounts here. And last thing we talked about a lot, especially with regards to the business owners, if someone wants to contact you about their estate planning needs, what are the best ways to reach out to you?
So the best way is to just give us a call. Our number is 727-545-8114. And we do free consultations when it comes to estate planning. So just let them know you want to review your estate plan. They'll set up a meeting. If you do set up a meeting, definitely would recommend bringing any current estate planning documents into that meeting. I always like to look through them, explain to you exactly what those estate planning documents mean, and see if they even need to be updated. If they don't need to be updated, I would just let the client know that their documents are fine, do exactly what they want already, nothing needs to be done. So pretty common for us to do it that way.
All right, John, thank you so much.